Please start, ma'am.
Good morning, everyone. I, Rinkle Chaudhary, Department of Pharmaceutics. I am honored to be spoken here today at the national level online faculty development program organized by Sardar Patel College of Pharmacy and association with Gujarat Technological University on the topic Smart Research for the Digital Age Master in Grant Proposal, High Impact Scopus, Publishing, Patent and AI Driven Excellence. On behalf of Sardar Patel College of Pharmacy, would like to present a very warm welcome to the present faculty, esteemed guests, and our fellow participants. I welcome you to all the fourth day of our faculty development program. Yesterday's session set the stage for an enriching experience. It was wonderful having a Dr. Ketan Raj sir. And sir has effectively outlined writing a effective research paper with meticulous attention to detail. And today we promise to be equally insightful. Let's dive into discussion, learn from each other, and take back valuable knowledge to our institution. Today we have an exciting lineup of sessions designed to enhance your research, review, and industry engagement skills by our profound speaker, Dr. Vijay Shivpuje sir. Let's build on the momentum from yesterday and make the most of this opportunity to learn, share, and network with fellow educators. So now I would like to welcome our FTP coordinator, Mr. Samresh Palroy sir, to introduce our guest.
Okay, thank you, Wrinkle ma'am. So it is my pleasure to introduce Dr. Vijay Kumar Shivpuje, a highly experienced expert in the field of intellectual property. He has more than 20 years of experience working in the pharmaceutical industry, law firms, and consulting, especially in the area of patents and design. He is also a registered patent agent with the Indian Patent Office, which means he is officially qualified to handle patent work in India. Dr. Vijay Kumar Shivpuje has a strong academic foundation that combines both science and law. He holds a master degree in pharmacy, which gives him deep knowledge of the pharmaceutical field. In addition, he has completed an LLB, Bachelor of Law, which equips him with legal expertise, especially in the area of intellectual property. This unique combination of qualification help him understand both the technical and legal side of patents and design. Dr. Shivpuje is currently the director of Patlex Business Solution, a company that helps other business with their patent and design work. He is also the CEO of Edu Literati, an online educational platform that offers skill-based learning to students and professionals. Through those roles, he is helping people protect their ideas and gain useful knowledge in the simple and affordable way. In addition to his main job, Dr. Shipuje also supports the government of startups. He is an IPR advisor of ASOCAM, a mentor of change with Niti Aayog, Atal Innovation Mission, and a mentor for Startup India. This role shows him commitment to guiding young innovators and entrepreneurs across India. He has also received award for his work, including the IPR Mentor of the Year 2024 and an award for IPR Awareness in 2021. Dr. Shivpuje is also passionate about spreading awareness of intellectual property rights. He has conducted over 300 awareness program. Yes, more than 300 awareness program. He has conducted different universities, colleges, law associations, and industries. His goal is to help people understand how to protect their ideas and turn them into successful innovation. So please join me in giving a warm welcome to Dr. Vijay Kumar Shipuje sir to deliver his talk on significance of patenting in the journey of an invention from lab to market. Over to you, sir.
Hi, thank you so much, Samresh ji and Wrinkle ma'am for the warm welcome as well as the introduction. It's pleasure to be here on this specific platform, which is a eFDP by Sardar Patel College of Pharmacy in association with Gujarat Technological University on smart research for the digital age, mastering grant proposals, high impact scopus publishing, patents, and AI-driven excellence. I believe this is the fourth session in this specific series, and I have been given this specific opportunity to speak on patenting in the pharmaceutical field specifically, as well as how we can actually think about commercialization from the lab actually for the research inventions that are happening in our labs as such. I'm also thankful to Honorable Principal Sir, Dr. Dhaval Patel Sir, as well as the Vice Principal, Dr. Rahil Bura Sir, for providing this platform as well as the opportunity to be here today. Uh, of course, there was a lot spoken about the activities that I have been involved into in the introduction part. But let me tell you something which was not part of it actually is that at the core, at the heart, I always felt to be a like a teacher actually, and I like teaching basically, and that's kind of passion. But unfortunately, what is happening out is when we look at uh, typically what teachers are doing, most of their time, unfortunately, is being, I would say, utilized in more of the administrative activities. Like, long back, 25 years back, the teacher was expected to teach. Then there were expectations that the teacher should also do some kind of research. Then came the expectation that, okay, beyond teaching research, the teachers should also be involved into he should or she should have a PhD degree as well. Then it all started. Okay, you have to go for some kind of activity, administrative activities. One by one, it started with NAC, it started with NIRF, it started with lot of agencies pushing so much of the things coming to academic institution basically. And the core of teaching has been, I would say, the teaching or research is completely sidelined. Why I'm saying this is I have been associated with at least 70 plus pharmacy colleges as such in various capacities, uh, dealing with their inventions, filing the patents for them, conducting a lot of workshops for students, for researchers, for faculties as such. I have also been seeing the progress the institutes are doing, and unfortunately, to some extent, the administrative activities are actually working as a hindrance for the research activities. What is the way out but then, and what is it expected? Now with NEP, what is expected that, okay, you are a teacher, you are expected to have at your institute, you are expected to have some kind of startups, you are expected to generate revenue, you are expected to have those activities related to incubation at your institution as well. Honestly speaking, now we have almost 210 participants. There would be very few who really understand the meaning of incubation basically. We have been given a lot of opportunities to hear a lot of speakers. What is incubation basically, and does it really work for pharma? The answer for me is no, and how I'll tell you during my presentation, because incubation doesn't work for pharma. Then what works for pharma as far as the commercialization is concerned? How are we going to ensure that what we are doing at lab level can be commercialized basically? Or what are those activities which are being, I would say, suitable for the commercialization purpose? Beyond this, if you look at the trends, recent trends actually in the academic institutions, there have been a lot of IP filings. Let me tell you, as a first generation entrepreneur, I worked for 12 years with pharmaceutical industry, the best of the industries which the students aim for to get a job right now. And after that, in 2017, I left my job, started my own venture, serving the community basically with respect to IP innovation and all. That very first year, we had got 18 patent filings in 2017. And let me tell you how we have progressed. In this, we just finished the financial year. We had 150 filing. Last month, we filed 30 patent application. There is a huge increase in the numbers basically. Over a period of time, we have filed more than 400 applications. 88 of them are granted now. But let me tell you, as far as commercialization is concerned, just one is commercialized. That too, it was from a MSME or a company actually. Now, where are we lagging basically? What is that one thing that is required basically with respect to commercialization of the pharmaceutical invention? I'm going to speak about pharmaceutics. I'm going to speak about pharmacochemistry. I'm going to speak about pharmacology, pharmacognosy, industrial pharmacy, everything wherever research is happening in pharma basically, right? And with this brief, I would say a background, let me move on to my slides to take the topic that has been allotted to me ahead. Just for a confirmation if my slides are visible.
Yeah, it is visible, sir.
Yeah, thank you. Okay, so have there have been instances wherein people approach us. Let us People approach us and they tell us that okay, we have got this particular invention, and then we are going for a publication or research paper publication basically. And since all of you are teachers, I'm pretty sure that you are aware of the concept of a research paper, how a research paper works. Let me start with what you exactly do and what I do as a patent agent. Firstly, I'm an M.Pharm Pharmaceutics, so I understand your language really very well. At the core, we need to understand that when we think of patenting, it is not about the law, but it is always about understanding your technology first. What does that mean? It means that if I go to a lawyer, and let us say the lawyer is from arts or commerce background, I may not be in a position to convince him or her the difference between dry granulation and wet granulation, or solid lipid nanoparticles and liposomes, basically. So, typically for the invention, it is a myth that patent is a legal document. No, it is not a legal document. It is a purely a techno legal document, basically. Just 10 to 20% of part of it is only legal. Everything else is technical. So unless and until the the agent or the attorney understands your language, understands your invention, he or she may not be in a position to actually uh, draft it well, present it to the patent office, as well as get it granted as such. Now, how does this practically work when we think of a research paper and a patent application? Generally, in case of research paper, as we know that you have it as a completely technical document basically, so no legal part is involved. Similarly, you just have the rights as an author basically. That means you do not have the legal right or legal ownership over that particular invention. Anyone can use that basically. That means that's where the commercialization aspect comes into play. If your invention has any commercialization potential, and if you publish it as a research paper, anyone can commercialize it. However, However, in case if you are filing it as a patent application, only you would have the legal rights as such. Then there is a fundamental difference between how a research paper gets published and a patent application gets published as such. Firstly, firstly, the research paper is published after the analysis, that is, whether the invention is or the research that you have carried is novel or not. Now, that's the primary criteria any research journal actually evaluates with respect to publication. Let me tell you one thing about patent application. The patent application gets published without any analysis or without any evaluation per se. That means you take any paper, file it in the form of a patent application, and it gets published automatically after 18 months. Now, what is a patent basically? Now, in case of patents, we have two different types of terminologies. First is a patent application, and second is a patent which we call once it is granted, basically. Now, unfortunately, people do not understand this difference. They celebrate the publication of a patent application. I've seen it so many times, basically. This is a normal process. You file literally anything. I have seen one-page document being filed as a patent application. It gets published because that's the process. That's the process, normal process. What is significant is that after filing, the actual examination starts. After filing, that means there is no examination. In case of research paper publication has, I would say, that analysis. Of course, you know better how research papers are published nowadays, but then if you look at the bigger ones or the ones which are well known with a higher impact factor, at least they are analyzing it and then only they are screening it, basically. Now, another fundamental difference is in case of research paper, there is no fees. Of course, there are research journals who are asking for fees as well nowadays. In case of patent application, from filing till grant, there is always a cost involved. And this cost may vary on what kind of invention you have, what kind of data you have generated, what kind of understanding your patent agent has, as well as what are the charges that the patent agent or attorney actually is getting from you, basically. Now, research paper generally gets published within after one or two reviews, let's say, or within a specific time, depending on the research journal, basically. In case of patent application, we have a standard timeline of 18 months. After 18 months, the patent application gets published. Try to understand, this is not the grant of a patent. This is not a grant of a patent. Rather, it is just normal publication of a patent as such. Now, patent office, which is a government of India office, actually has come up with something called as an early publication. If you want, then the application can get published within 1 month as well by paying some extra fees, basically. Now, uh, is this required? Yes, there are pros and cons in both the cases. If you get it published earlier, or if you get it published later as well. I'll discuss those things in detail later. Now, uh, in case of research paper, the only fundamental criteria is having novelty. That is, if the invention is new or not, basically. Now, in case of patent and patent application, we also have a criteria which we have, all of us have studied at some point of time, that novelty, non-obviousness, and industrial applicability. That non-obviousness also called as a, I would say, uh, uh, inventive step in the typical Indian context as such. The term that is used is inventive step, basically. Now, as I discussed, in case of a research paper, you do not have any legal rights and anyone can commercialize the invention. Now, in case of patent application, you or licensee can only use the specific rights as such, because they are legally created jurisdictional rights. Means what? So just like for your phone, or like, let us say uh, for your car, the registry is in your name, so you own that car. Similarly, when you have patent, then it is presumed that for that particular invention or patent, the legal rights are yours and you own the legal rights for that as well. Now, one of the things that I was told during my master's time, when I studied my master's at Pune College of Pharmacy, that point of time, my guide, Dr. Anand Paradkar, used to tell this, that if you want to write a good research paper, for sure, you need to have a lot of practice, actually. And let me tell you, with this experience of last so many years, even in patent drafting, you require a lot of practice, understanding the invention, because every invention is different, basically, although it is coming from the same lab as such, right? Now, one of the most crucial or significant part in case of research paper is the results, actually. Now, in case of patent application, we call it claims, which are the only legal part in the entire document, but they are the most crucial thing as far as the patent application or patent document are concerned. Now, it is said that claim drafting is actually an art to put the science in a legal manner. Let me repeat it. Claim drafting is an art to put the scientific invention in a legal language, actually. So it is something, and for that very reason, it is very essential that your agent, I would say, attorney should understand your invention first. Unless and until I understand your invention, how am I gonna put it in a legal manner, that too artistically, that too presenting at patent office and getting it granted as well. So this is a fundamental slide that I thought to just to get connected with all of you, because you are very much aware of the concept of research paper as such. Now, over 300 plus IP awareness sessions, and I have been thrown with lot of questions, and there are a lot of myths about patenting, actually, although they seem simple questions, but then these are the most crucial myths that need to be busted about the patent application or patents as such. Now, what is that timeline at which I should file a patent application for the research? Let me tell you, be it aesthetics, chemistry, pharmacology, pharmacognosy, industrial pharmacy, any field that you are into and you are doing your research for, let's say, the master students, or I would say for the PhD as well. At that for that research, actually, you can go for patent filing. Rather, we are working with few of the research institutes under MOU and the confidentiality disclosure agreements, wherein all the theses that go to the university, before going to the university, they come to us. We evaluate whether there is any patent aspect that can be actually, I would say, there, and can we file a patent application for that? But fundamental question, when should I file patent application? Do I need to wait for all the data that gets generated? Do I need full-fledged preclinical clinical study to file a patent application? The answer to this is absolutely no. You can file the patent application at the hypothesis stage only. Now, what do you mean by that? So the moment you start thinking about a project, you think that like a taste masked tablet composition of metformin is something that I'm gonna work. And I believe that this would have some advantage. This would have some practical, I would say, utility as well. And I know how to prepare it actually. So that's my hypothesis that the for metformin, taste mask tablet composition can be prepared. Now, that point of time, you can go for patent filing without any data being generated. Now, this is what we call as a provisional patent application. That means why are we filing this at this stage, and why are not we not waiting for the results to be generated for that? First thing is that we have a system called as first to file. That means the one who files first gets the patent first. The one who files the first. So, first come, first serve basis, basically. If you do research earlier and you are not vigilant about your research, someone else files a patent. In that case, that person would get that advantage, basically. And then once we file this as a provisional application, you would have 1 year, and I am pretty confident in ecology, Sutex, cognosy, or chemistry for that sake, 1 year is a sufficient time at a normal pace to generate the data related to that. Now, what is the data that is required? It always depends upon what are you claiming. It is not, in few cases, a simple physical characterization data is sufficient to get a patent granted. In case of a tablet, it may be a disintegration, friability, dissolution studies, stability studies. It's absolutely fine. In few cases, even clinical data may not be sufficient to get a patent granted. Now, how does it matter? What are those factors on which this is dependent? So basically, the data that need to be generated depends on just one thing, and that is claims part here. So claiming strategy decides what data is required, basically. Now, the next question is, why should I file a patent application? Speaking in front of so many faculties from the pharma community, uh, honestly, if I tell you the reason that you have to protect your invention, you have to make sure that the legal rights are with you. I think that is the theoretical thing. Let me tell you the practically, the rather whenever any client comes to us, any new invention comes to us, the very first question I ask is, why do you want to file a patent application? Most of the times the answers are CV, promotion, NIRF, NAC, NBA, research ground. Beyond these are the practical reasons everyone is doing it as. Now, the key question is, even I feel now, because the business is stable, we are filing so many applications for almost everyone, most of the academic institutions as well as the corporates. Is it really worth putting money into filing patent application and creating those numbers, basically? Let me try to give you a different policy perspective on this answer. Why is it expected as an academic institution to have, let us say, the IP cell, the IP policy, or the patent filing ecosystem? It's absolutely fine that, like, probably we may not need these systems at this point of time. The essence or the policy reason behind actually having these systems at academic institution is that maybe not today, but after 5 years, 10 years, there would be students. The Gen Z, the next alpha generation, they are pretty smart. They come up with good inventions. That point of time, you may not be knowing actually what need to be done with these invention. And let me tell you, many a times the inventions get killed right there because there is no legal protection. It feels really very bad when your idea, your research invention, which had a potential, someone else selling because they are better businessmen, and they are taking your ideas without even crediting you a single penny out of it as such. So the intent from a policy perspective herein is to create that ecosystem at a academic institution or university level rather than running behind the numbers, I would say. But that's how the system is working. Everyone is running behind the numbers. Everyone else wants mere itne patents hai, like, itna numbers hai actually, like, but at the end, it starts with the quantities, and at some point of time, once it is stabilized, you would require the quality patents. It may be just one in over 5, 10 years. That's absolutely fine. It should have commercial potential, actually. If you, in fact, look at the NIRF's perspective as well, the way NIRF has, or I would say NAC has grown over the years. Initially, I remember when I started in 2017-18, that point of time, these agencies were asking just for patent applications filed. Then came a time wherein they started asking how many of them are published. Then came a time when they are asking for how many of them are granted. Now, granted has a more weightage now. Beyond that, now they are coming up with, okay, how many of them are commercialized? That means patent is just a means from lab to commercialization. Is it mandatory? No, it is not mandatory to get a patent for your invention if you want to commercialize. Patent as a concept works on a negative principle. अगर मेरे पास पेटेंट है doesn't mean I can commercialize my invention. Let me repeat. अगर मेरे पास पेटेंट है doesn't mean that I can commercialize my invention. Why is it so? Reason being that you would still need the FDA approval for your new drug. You would need the DCGI approval. You would need the license, and that license, let me repeat here, the license, the FDA has nothing to do with patents. FDA, the drug regulatory approval, and patents are connected the way South and North are connected. They do not have any connection, basically, as such. So FDA think regulatory approval for commercialization is mandatory. Patent is not mandatory. Then why is everyone going for patents then? As I said, it's all about the numbers game. It's all about the rat race that everyone is running. मेरे पास इतने patents है. I need this for the NAC purpose. I need this for like, maybe research grant. Every agency is asking, and that's how you're filing a patent, actually. What data do I need to file patent application? I think I have already covered this part, that depending on the claims, depending on your invention. Okay, let me be precise now here. For a pharmaceutical formulation, that is a typical, I would say, dosage form, uh, or from pharmaceutics or industrial pharmacy or QS, the project are from Sutex in that case. Physical characterization of dosage form and stability data is sufficient for filing or even getting the patent granted, basically. Now, next, coming to the chemistry part. In chemistry, if it's a new drug, in that case, the characterization of the API, physical characterization of the API, as well as I would say uh, at least some uh, preclinical or in vivo study showcasing the activity of that new drug would be sufficient. We have got a lot of patents granted like this. For the processes, for the process for preparing API, simple data like the yield, the advantages of that invention, like it may be economical, it may be, I would say, environmental friendly, with data, that would be something which would be sufficient. Let me go to pharmacology. There are myths, pharmacology and pharmacognosy. There are myths that herbals are not patentable. Rather, we have got an expertise into this herbal patenting or Ayush patenting. We have also come up with a course on which is running currently, which is herbal and Ayush patenting actually. Even Patent Office, Indian Patent Office has come up with guidelines for patenting in Ayush systems of medicine or herbal patenting. So it is possible. Therein, what data is required actually. So I'll tell you how it practically works. In case of pharmacology and pharmacognosy invention, you need to put it in the garb of a composition basically. So how does it work? If you're preparing a powder, extract and powder out of that extract basically, and then checking its activity, that point of time, I won't call it an extract. I would call it as a powder dosage form. It is it is always how you put it actually, how you claim it, how do you actually put it in the specification, how do you actually put it in the claims, that matters more rather than what you have done. And that's where I said it is very important that your agent or attorney should understand your invention first. Now, in that case, simple animal study, preclinical study is sufficient. We have got so many out of 88 patents. I think we have got at least 50 or 60 which are from herbal domain, basically, which are granted as such. So the data depends on what kind of claiming you have, what is that research basically. Now, a very interesting question was asked to me. Shall I take help of a patent agent for patent filing? Honestly speaking, patent office doesn't make it mandatory to take a help of a patent agent as such during the filing processes, basically. But then, are there ways? Yes, you can do on your own. You can go to patent office website. Electronic filing is available. E-filing is available. You can do that. If you are based in any of the four metros, Mumbai, Delhi, Chennai, Kolkata, then you can go offline. Patent office is really helpful for offline filing of the patent application as well. It is not mandatory. So why should I take help of a patent agent? Now, see, if you want to file and get it published, do it on your own. There is no problem for that. You would save the agent's money or the cost, basically. Okay. Now, in case of I would say you want to take the inventions ahead till the grant stage as such, that point of time, I would say you should take a help of a patent agent, because now it's not a technical, it's a techno legal document, and you need to get it, I would say, granted with the help of a patent agent. Again, it's not a mandatory, but then when you try to do that on your own, you may not be in a position to convince the controller, basically. I have a very interesting question in the chat box, which is from Bhagyalatta Satpati. Is there any patent related to QA or analysis? That's an interesting question. Again, now there are certain things. So there is a very famous quote by US Supreme Court, which mentioned that anything under the sun that is made by the hand of a human being is patentable. It also includes the invention from the QA domain as well. However, it should just satisfy the criteria of novelty, non-obviousness, and industrial applicability. Now, in few of the cases of QA or analysis, actually industrial applicability criteria is not satisfied. But in that case, you may not, I would say, it may not be, I would say, getting patented basically if there is no industrial applicability as such for that particular invention. But again, if your invention is typically for either from, because I remember the QA project side are many a times into the dosage form or into the chemistry basically. In that case, definitely it is possible. I would like to answer also this specific question in a way that like, depending on your invention, what kind of invention you are doing, depending on that we can take a call. But yes, the flat answer is not yeah, like, yes or no. It's a gray area basically, but then we can take it ahead independently as well. I also got one more question from Dr. Rahul Sable. Please, more details of pharmacology animal activities patent. Okay. Now, India, we have a specific section wherein section 3I, which excludes the patentability of second medical use, basically. That means that means uh, you cannot claim something which is already there and you are coming up with a new use of that. Isn't it exactly the same thing you do in pharmacology? Yes. Now the thing is that we have for example, there is a product or a herb which was being used for let us say diabetes earlier. Now you are trying it for rheumatoid arthritis. Now, how we can actually claim it is, what you can do is, instead of going for a herbal activity or a medical use, again, there is a way to draft it. What I would do is a topical dosage form for, like, for that particular herb, which can get the I would say patent application drafted as well as granted as well. So in case of pharmacology, it's about tweaking the language. Rather, I would say one of my earliest patents which was granted was from the pharmacology domain itself as such. And I have a lot of clients from pharmacology and pharmacognosy as such, which are for which we are actually working. Uma Chandra, I'll share the details of the course and my contact details at the end of the session. I have got one question. How can we proceed for patent related to microbial product processes involved in microorganism for production of bioactive? That's an interesting question. This is coming from PhD 05. Okay. Uh, now there are two separate aspects in this. One is one जो हमें typically which have been taught to us during our, I would say, undergrad or postgrad days is like, I would say the product and processes basically. Now you can either go for product or process. Now in these kind of cases, product claims at times become difficult because it was already there and you are just isolating it, or you are just, I would say, characterizing it basically, right? Now in that case, it is very difficult to get patented basically because it is already there basically, right? Now what happens is, as far as the processes are concerned, yes, it is possible basically, and there have been instances wherein it is basically done. So how I recommend to do this is that first part, what you can do is you can actually come up, instead of simple isolation of that particular, let us say, product, what you can do is you can at least have some kind of hello, some kind of human intervention with respect to
You are not audible, sir. I think I need to. One second. Yes, sir. Please, you can unmute.
Yes, thank you so much. I'm extremely sorry. Yeah. So what is required, what is recommended is simple, not just simple isolation, but about, I would say, what you can do is some kind of human intervention. When I say human intervention, you have isolated, process it. It can be purification, it can be particle size reduction, it can be spray drying, it can be lyophilization, and then you can get it as a product as well. That's what my recommendation for this microbial product kind of question. Dr. Jayaprakash Kadian, can an animal study of herbal extract be patented after publication? Now, so exactly this is my first worry about the research. Why are you publishing first? See, once you file a patent, you can still publish it basically. But if you publish it and thereafter file a patent, it is not possible basically. And this is exactly what you need to avoid. File a patent first and then publish, that's absolutely fine. But if you publish first, although it is your own research paper, it acts as a barrier for getting a patent granted as such. So for this question, the answer is there is a way out. We have 1 year kind of, I would say, a 1 year grace period available. But then, as far as the interpretation of that grace period is there, it is very much tricky and it's very difficult. So we tell the client to avoid publication first, go for patent first, and then actually can go for, I would say, go for patent filing and then go for publication. Rakesh Panda, can we proceed for patent application is already published in a reputable journal? The answer is absolutely no. आपका nature में भी published है, still it cannot be patented once it is in public domain. Now, how does it actually work? It is just not a, and then many times the client realize there is a potential, हमने patent पहले file करना था, but we couldn't do that. They try to tweak the invention basically. थोड़ा सा मैं changes करता हूँ sir, हम इसका patent file करते हैं. Let me tell you what happens. Your invention becomes novel that point of time. However, the invention is not having inventive step. That means your prior art kills your invention. Without animal study, we can patent our master's work. Absolutely, Mansi, it is very much possible as such. I think I have already discussed. I got this question from Dr. Maitri Zaveri. One herbal drug which we have used is already mentioned in an ancient book. We have done work on this mentioned use, developed a dosage form with all proven result, but they reject a patent that claim is mentioned in traditional knowledge. What can we do? I think Dr. Maitri, this is exactly the point. Herbal drugs के लिए patenting is feasible, but you need a smart way to draft it as well as convince the controller. See, curcumin, we know for wound healing is being used, right? What is important is how we claim the invention basically, and how we can actually put it basically in terms of, I would say, the patent document, and that's how the patent can get granted. In fact, the as I mentioned, the herbal and Ayush patent, we did a course with KM Kundani College of Pharmacy in 2019, which was herbal patenting, wherein we had a lot of industry participant as well. This year as well, we have got a lot of industry participant who are we have joined for this herbal and Ayush patenting course. Of course, with the permission of the organizers, I can share the details at there. Then I have got this question, Dr. Abhishek Kumar. Should we mention about file publish? Yes, you can do that if you want. Charu Mehta, how can we get information about approved patent related to any area? So that can be done on the Patent Office website as well as Google Patent and eSpaceNet answer, right? Let me move ahead with the my questions. And in fact, this is exactly my question. Was next question, can I publish my research before patent filing? The answer is absolutely no. The absolutely no as such. Uh, uh, so uh, 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 what I'll do is, Samresh sir, in between wherever I feel that the questions are relevant, I'll take those questions, and remaining at the end we can for sure take.
Yes,
Okay?
sir. Yes, sir.
Uh,
Please, please.
yeah. How much is the cost for patent filing? I have an interesting slide to discuss this actually. कि कितना official cost है और कितना agent charge करता है. Can a, can I file a patent application without telling my institute or guide? That's a question being asked to me, as well as this is the question which I have faced in my real life actually. A student comes, tells me, sir, मेरे को patent file करना है, हम सारी formalities करते हैं. She says that I don't want to include my guide's name. What can you do as an institute in that case? What would you do as a guide at that point of time? Remember, the patent application gets published after 18 months. तब तक वो स्टूडेंट कहीं यूएस कनाडा यूरोप में जाके या किसी इंडस्ट्री में स्टेबल है, सेटल है, जॉब हो लग गई है उसकी. But how are you gonna protect this? Another question is, can someone else file patent application of my invention? See, if the answer to both of these questions is yes, it is possible. Let us not go into ethical part. Let's go into the legal part actually. Unless and until you have an IP policy in place at your college, at your university, students can do that. What if a professor shifts from one institute to other and then uses the invention of first institute at a later institute basically? All these things are patent office never checks it actually. Patent office never asks you that where did you carry out the invention, right? There are legal ways to check this later, but then it would be quite expensive. So it is very essential to have these things controlled upfront basically. That's where I would say the real challenge is, as an institute you need to have a IP policy. And if you want, we as a company, as a firm, we are helping a lot of institute to have their IP policy in place, and we are doing it completely free of cost. If you want IP policy for your institute, just ping me, my team would help you out. Let us go to what happens after filing. Rather, I'm going to cover that entire journey as such. When does the patent application gets published? I have discovered this after 18 months. In few cases, it can be initially, with the extra fees, it would be as simple as within 1 month or 1 week as well. How much time does it take to get the patent granted? Now, generally, the timeline required is in pharmaceutical cases 2 to 3 years. That's what you should presume. Try to understand, patent office is not allowed to grant before 6 months after publication. And the best as a firm that we have got is 6 months and 14 days actually. Now, try it. See, it is unlike a trademark or a design. The most significant thing herein you need to understand is that herein, what you worked for 5-6 years, that the controller or the examiner has to understand, digest, and evaluate, and then give a examination report. So it is a timely process. It's not gonna happen in a day or a month actually. So it's like minimum up lagalo 7 months, maximum 2 to 3 years basically. Now, does publication of application assure you a grant of a patent? Absolutely no. Because the publication triggers examination. Publication के बाद examination होता है. The examination of patent application happens after the publication basically. So publication is a normal process. As I discussed, is paper ko, if you put it in a patent format, it gets published, but this doesn't get granted basically. What is the cost? I'll discuss this. There have been a lot of instances wherein people get confused between design and a patent. Now, and rather, I get a lot of calls to discuss about the design patent concept. Let me discuss a very interesting fact here, and I am pretty confident many of you are part of this so-called design patents. There is nothing called design patent in India. It is an industrial design. Then there is this myth called UK design patent, German design patent, Australian innovation patent. Now, firstly, there is just in India, we have a patent and we have a design. In fact, this particular slide, I have a wonderful video which is available on my YouTube channel actually, wherein I discuss how the systems are corrupt with respect to this design patent, German utility model, and I would say the Australian innovation patent and all. Try to understand this one aspect herein. You as a scientist, you as a pharmacist, is there to do research. What is design basically? Design protects the shape of a product. How does this look? Now, as a scientist, you are not there to let the product look pretty. Now, what is important is you are in research, and for research-based invention, you have only one type of IP, that is patents. Now, why this is happening? The design, the utility model provides you secondary protection basically. India mein utility model nahi hai. You call it a German patent, you call it an Australian innovation patent. That's not a patent basically. Now, maybe even the policy makers need to understand this, that a design is just for the shape and is not an invention basically. Are you doing research to improve the shape of a product? No, it's the utility, the functionality that matters. In case you are working as a scientist or you are doing research basically. Now, all these are kind of, I would say, to some extent, certain malpractices which are being involved. My humble request to all of you is that, if you are a genuine researcher, these things are not going to help you in a long run. What is going to help you in a long run is just patents only. The Indian patent, the European patent, the US patent, everything else. Then they come up with a South African patent. Let me tell you, South African patent doesn't have examination. आप फाइल करो, वो ग्रांट कर देता है. There is no examination at all. Right? Now, is it going to give you the real value? See, you can tell your students, you can tell your institute, you can tell your management, you can tell your NIRF, NAC, but at the end of the day, when it comes about the commercialization, there is zero value for design. Design ka value, the design has value only when, I'll tell you does the value come from. If you are working on a device, let us say respiratory DPI, dry powder inhaler, or metered dose inhaler product, and or a spray product. Let us say this is a kind of a spray product, nasal spray or oral spray kind of product. The design of the product is in such a way that it is something which is critical for the functionality or the quality of the product. In that case, only the design matters. Otherwise, you are doing injustice to the research. If you are doing for the sake of getting the KRAs or fulfilling your criteria, that's absolutely fine. At least don't get your students involved in that. Otherwise, I'm telling you, at some point of time, what is happening out actually? Like if you look at it, maybe at a very premier first year institution, the professor says that I have got 5 or 10 patents. And then at a third or fourth tier institution, जहाँ पे research facility नहीं है, let us say, they are saying that I have got 30 design patents granted. Where is that comparison basically? Right? So design is something again for the purpose of getting I would say your numbers or fulfilling. So let us be very clear. Why are you filing it? If you are very sure about, then that's absolutely fine. Design is only for devices, I'm telling you. It is only for devices. And if your inventions are with respect to devices, that's then you can go for real design. That's it. Of course, we also do a lot of design filing actually. Medical devices, biomedical devices, they are wonderful. Design has connection with the utility. In that case, it works really well as such. Now, this is the one slide which would give you an idea about how does the financials work. How to file a patent application. इसमें the filing fees is 1600 rupees only. Request for examination is 4000. That's mandatory. If you go for normal publication after 18 months, there is no fees. And then if you want to go for early publication, 2500. इसके beyond form 26, 500 rupees. 8600 is the maximum amount that is actually goes to as a expenses with the patent office and the I would say the power of attorney or the stamp duty basically. Everything else goes to an agent. This also provides a lot of career opportunities as patent agent, because patent agent charge very differently depending on their expertise, depending on what they are doing, depending on the complexity of the invention, and a lot of n number of factors for that sake actually. Now this is the only cost which goes to our expenses basically. Now what I have got is a general process. I'll quickly run you through the process. When a client comes to you, or let us say any one of you comes to us, we initially file a confidential disclosure or non-disclosure act. We evaluate the patentability as a team. Then we go for drafting of the patent application. We get a power of attorney from the applicant that we are represent. This is not the power of attorney जो बाजीगर मूवी में शाहरुख खान को मिला था. Power of attorney is very specific that I am as a patent agent, is in a position to work or represent you at the patent office. So it is a very specific power of attorney, basically. Patent filing, we do patent filing with necessary forms and fees, जो मैंने अभी आपको दिखाया. Next is patent prosecution. What is it? हम next कुछ slides में will see it actually. What is a patent prosecution? Then the patent gets granted. You have to maintain it by paying the renewal fees, and you have to enforce it if someone else uses your invention. How does it practically work? Let me show you with this. So we get a patent, a thesis we sign a CDA, we get a thesis basically from a institute, master's, yeah, PhD thesis. We as a team, so I have a pharmacologist, biotechnologist, a chemist, a dentist, and 2 people from pharmaceutics masters who are working with me. 5 of them are patent agents actually. Now, once that invention is shared, we generate the patentability report. Means what? We tell the client कि इसका patent मिल सकता है कि नहीं. And then the client need to decide whether we should go for drafting and filing. Once we draft, that point of time, we get this receipt for application filing. That is AFR, we call this. It includes date of filing. Look at here, the CBR date. Then the application number 202021031705, dated this in the name of this, and its title is a solid lipid matrix composition comprising tetracycline hydrochloride. along with the fees of 1600 rupees. Now you are open. Now you are open to share your invention. Now you can publish it. Now you can use this number in your CV, in your NIRF, NAC, NBA, whatever you want to do, right? Now, on the day one itself, you get this AFR application filing receipt. After 18 months, all these inventions are from pharma. So this is from Dr. Rajni Atali, K. M. Kundani College of Pharmacy. This is microsphere loaded menthol. After 18 months, the application gets published. Actually, look at this. 9th December 2019, 18 months add कीजिएगा, 9th June 2021. तो upcoming जो Friday होगा, उस date को the application gets published. It would include the applicant details, the inventor details, the abstract. All your forms prepared are available on the patent office website as well. This application is for Dr. Chanchaldeep Kaur. Next, then comes your request for examination and first examination report. If you look at this, there is a fees for request for examination. Unless you file this, you may not get the examination report. Now, what is examination report? Examination. So this is for Dr. Shailendra Saraf, this application which we prosecuted. This application, once we get the examination report typically includes novelty, inventive step, non-obviousness, industrial applicability, patentability under Section 3. Now, what is this? This is the place wherein you need help of a patent agent to understand. अभी जो हमने theoretically whatever we have studied, the novelty, inventive step, industrial applicability, अभी practically you have to convince the controller about that. Okay, now this is something which is, I would say, you get the examination report. What we do is, once we get the examination report, then we file. So this is for CU Shah College of Pharmacy, Mumbai. This is a reply for FER, first examination report reply. We submit the reply. Now, this is where you need a help of an agent. Now, after this, what you do is, many times the patent gets granted. If the objections are made, the controller is happy with your invention or the reply. In that case, your invention gets granted directly. But as a process, there is something called as a hearing. Now, what is hearing notice? Hearing is the first time when you get an opportunity as a applicant, as a inventor to, I would say, to actually face the patent office basically, or the controller. Herein, till this date, the entire communication was happening through the documents आप submit कर रहे थे and they were reading it, right? Now this is the opportunity wherein you can convince on a call. And let me tell you, this is virtual hearing, firstly, and secondly, applicants or inventors are allowed to do that. Many a times we tell our client to join for the hearing as well. After that, this is the one which we got recently for a faculty from ICT. If you look at the date of grant, it is 26 March 2025. This is the grant certificate that you get at the end of the prosecution. But you need to understand, after spending so much of money, there is a possibility that your invention can also get refused unless it is presented in a proper way to the patent office, or you are convincing the controller basically. And there is an unfortunate thing about pharma. Although we have so many inventions, pharmacists, there are no pharmacists at patent office. As an M-Pharm, you're not allowed to be an examiner or as a controller. This is an unfortunate thing. All the pharma inventions are being evaluated by life sciences, biotechnology, chemistry kind of people, and biomedical engineering. Unfortunately, this is the harsh truth. Now, this is how is the journey of invention from lab to the grant of the certificate. However, this is not the end of the story. If you look at the theme of our FDP, as well as the topic that has also been allotted to me, is something about taking the invention ahead from lab to the market, basically. Now, if you look at this picture, there is a very interesting and thorough message which has been given in this. The message is that you are a scientist, you have patents, and then suddenly you become Unsuk Wangdo. You want someone to give you $1 million. He's getting that multi-million-dollar check or money from Chatur Ramlingam. Does it practically work? In my journey of 8 years, I haven't seen any Funsuk Wangdu who is getting, I would say, money actually from Chatur Ramlingam practically as far as the pharmaceutical inventions are concerned. Why is this happening basically, and what is the biggest challenge that we need to face? Okay. As a word, intellectual property rights, the patent works on a principle of negative rights. That means अगर मेरे पास rights है ना, then no one else can use it. I can stop them. So Funsuk Wangdo has rights and Chatur Ramlingam wants to sell the product. He can't do that because Funsuk Wangdo has the legal rights. He has the patents, 400 patents. वो Chatur Ramlingam चाहिए. Now, the problem is that in our invention, in fact, I see this very frequently on LinkedIn. I'm very active on LinkedIn, and what happens therein is that the professors or the students, they publish, they post that, okay, I got this patent granted, and then now I am looking for some kind of, I would say, commercialization. I want someone to actually use the technology or commercialize the technology. Now, I'll tell you the myth and I'll tell you the biggest problem of the system. In terms of intellectual property rights, your intellect, your thesis is a property, and then you get a legal rights through patents, right? That's how the IPR works. However, practically what is happening out is that the inventions or the thesis, the intellectual activities are getting legal rights, but they're not properties. Why is it so? I'll give you with one simple example. When we think of a research project, research proposal, that point of time, we think of a publication, a patent, let's say, we never think of commercialization. Let us say this pen, which has a value of 10 rupees, would you give extra money just because this is IP protected? Absolutely no. Now, we are having thesis, we are having research for which we are having patents. But if you look at the value of the research in terms of commercialization, there is no value. Why there is no value? Basically, there is no value because we don't look at the commercialization aspect. What we do typically in this, see, these are very general and vague statement. These are not applicable to everyone, but most of the times this is what is happening. We are creating research, we are doing thesis, we are trying to come up with the invention and then try to identify the problem it solves. Rather, in many cases, we are trying to create that problem which doesn't exist, and हमारे solution से उसको solve करने की कोशिश कर रहे हैं. That is not the way the invention is commercialized. The patent or the see, patent never gets commercialized. Try to understand this fundamental fact. Patent never gets commercialized. It is the technology, this technology gets commercialized, but it gets commercialized, and once it gets commercialized, you should have the legal protection for this. हमारे साथ क्या हो रहा है? We have the technology, it is patented, you have the right, but is it commercializable? No. तो right का क्या करोगे? Why are we taking legal rights? The fundamental thing is that we are taking legal rights just because NAC pressure दे रहा है, NIRF का pressure है. Like, we need funding coming from our universities. Like, there is a severe competition to show that we are innovative. We are innovative, but is this innovation, whatever you have done, is it useful for the public? Can it be commercialized? The answer is no. Why is it not? And what are the ways we can commercialize it? That I have included in my last few slides also. We came up with this concept called as Pharma Innovation Yatra. In 2017, we had reached 30 pharmaceutical colleges offline. I'm speaking about offline workshops basically. And this year, so that was at that point of time, it was all about awareness of IP. This year, the theme of Pharma Innovation Yatra 2025 is with respect to commercialization and technology transfer of the inventions. We are doing it. We have started. We did couple of sessions, one in Pune and one in Mumbai, actually, offline, guiding the researchers, guiding the faculties, guiding the master students, understand that why their IP is not commercialized. First thing is that, so this is a concept came by BIRAC. If you look at the slide, there is this link as well, which is provided. There is a concept called as a TRL, technology readiness level. And when you think of technology readiness level, you would see that if you are into 7 to 9 TRL, then the higher chance of commercialization. Now, what is 7? How these TRL works for new drugs or delivery systems? Ideation, proof of principle, POC. These are the three things: in vivo models, ex vivo models, preclinical, till actually, I would say the TRL4 level actually. Now, pharma inventions generally fall into TRL1 to 4. जो भी हमारे पास आते हैं, जो भी पेटेंट, एंड फॉर पेटेंट्स, लेट मी बी ऑनेस्ट, TRL level 2 proof of principle, not even POC, proof of principle is also there. Then, like, you can get a patent for that actually. But then the TRL, what is required, and we know, we have learned this in our B Farm, in our masters, basically, that we need phase 1, 2, 3 clinical trials actually. And that's what the TRL 5, 6, 7. The key question is, we don't have money. Let me tell you, no one has got money. Even the corporates do not have money to put on the clinical trials. Basically, there has not been an incidence wherein a new drug discovery molecule has come from lab till global markets, basically from the Indian context as such. Those molecules, one or two, which reached to a level, like, beyond that, they were either scrapped, like we had this example of balaglitazone, or we had this example of revamilas, let's say. Now, but then beyond the level, these could not take off as. So there is no money. Then how is that commercialization gonna happen, basically? Try to understand, this has nothing to do with patents actually. The TRL, technology readiness level, the commercialization. See, the technology commercialization and then protecting it by IP. These are two separate things. These need to be mixed basically for those inventions which can be commercialized for which you need to get a IP. But what is happening out? You have got good smart agents and you give me any technology, I can get a patent for it. Can I commercialize it? No, there is no way to commercialize it actually. Now, how the TRL level is evaluated? Again, this is coming from BITS Pilani Technology Enabling Center. These are the key questions which you need to understand or answer with respect to technology readiness level. Those of you who are in research, who are doing research, you would have definitely evaluated कि आपके product कौन से TRL level पे है. If you look at this, at least let us say a pharmaceutics department in collaboration with a pharmacology or a pharmacognosy department at least can come up with TRL level 4 actually, if there is a collaborative efforts basically. Otherwise, these TRL, you are not even at TRL level 2 and the products, you look at this, this is the graph actually which has been shown. 1 to 3 stages, just 12% of commercialization. Actually, as you move ahead, and these are global criteria basically, right? Now you need to understand this. You need to understand that getting patent has nothing to do with your TRL level as. Then comes we are kind of, I would say, pushed by so many agencies. So much of the content has been given to us in so many forums which speaks about incubation. What is incubation? First of all, incubation is something which guides you from lab to market, basically. Because a scientist, good scientist, may not be a good businessman. And there are processes which are required, the regulatory approval processes and all. A incubator typically helps you or mentors you to take the products from lab to the market. But try to understand, no, incubation is not meant for pharma products. Why? The key answer to this, I would say, is that the cost that is required from TRL 1 to 9, maybe in few cases for the US products, it may be 20,000 crore. None of the incubators would have these opportunities or these kind of, I would say, like, bandwidths as well as far as the incubation is concerned. The job of an incubator is actually to mentor the startup or the individual or the research project so that lab से market तक वो जा पाए. Can it be done by an incubator? Because incubators themselves, to some extent, are struggling with respect to funds as such, right? Because incubation center start karna is one thing, but beyond that, running it is like an independent venture basically. And see, incubation concept comes from engineering or tech side, but try to understand, for a technology, for launching an app, for launching a website, you rarely need any kind of, there is not much of regulation, there is not much of the cost involved. When I came up with my own platform, it was just 1.5 lakh rupees through which I could come up with. So वहां पे incubation हो सकता है. But if you tell the incubator that you need, let's say 5,000 crore rupees, like, kind of funding for your product to get commercialized, how is it possible as such? It's not possible. Not neither from the government, nor from the incubator, nor from the private funding agencies or corporates. Actually, let us try to be very practical to understand them. Then where are the opportunities then? I'm just not here to demotivate you, all the faculty members, but I'm here to let you know the harsh realities as well as let you know where are the real opportunities basically. The real opportunities are with respect to, I would say, the TTOs, the technology transfer offices. Again, when you think of, so TTOs are being given this opportunity basically, or they have been given this mandate to help the academic institutions, universities to commercialize these inventions basically. So we have a lot of them. So we have it in KIT Bhubaneswar, then we have it C Camp actually. Then we have one in Pune Venture Center. BCIL is there, TIPS is there in Trivandrum. There are many which are created by BIRAC. Beyond that, there are one or two agencies like NRDC, National Research Development Corporation, who have been actually acting as a TTO. What are TTOs doing? They are acquiring or getting these technologies from the academic institutions or universities, and they are the ones who are identifying the right partner for your invention. Now, you as an individual cannot scout for the the companies or organizations which need your invention. So they are doing it on your behalf. First of all, they are doing it completely free of cost. What do they do is, if the technology is out licensed or sold, they take certain share of it actually. That's how the TTOs work. There are a lot of techniques, but let us just think of licensing or out licensing. This slide is about out licensing. So the rights are with Amir Khan Funsuk Wangdo, and he is signing a deal. He is giving a license, just like property is mine, ghar mera hai, I'm giving it on rent. In the similar fashion, you would have the licensing deals basically. Try to understand an important aspect herein. There's a different science called patent valuation, wherein it is just not the business, but the economic and the legal side of it is also determined. Patent valuation techniques are there, jahan pe product strength, this business intelligence, and the valuation methods as well as the patent strengths actually matter. These are, I would say, highly established techniques globally. Actually, these are some of the approaches. I am not gonna go in details because these are more technical, as well as once you have that invention which can be commercialized at that point of time, how to valuate it, kitna royalty lena hai. For all that, all these valuation approaches basically are dependent on. Okay. Now, what is important for us? I'm ending my slides and presentation with just two last messages. Now, under MSME ministry, we have these reimbursement of IP, which is for foreign patents, the domestic patent, GI, the design, and TM. So for Indian patent, it is up to 1 lakh. But this is available only if you have a Udyam registration certificate. So if you are a startup or if you are a MSME, now under NEP, new education policy, you are allowed to do that as such, right? You can have your own venture. That point of time, you can get this as a complete reimbursement from Ministry of MSME as such. And I'll end my session with certain recommendation where should you focus on as far as the commercialization aspects of inventions or IP are concerned. Nutraceuticals and cosmetics are the areas wherein the lab to market barriers are lesser. Therein you should focus on basically. And we have seen certain level of activity post-COVID in nutraceuticals. Of course, it's a booming market. Even cosmetics, if you look at the big brands basically in the cosmetics, and if you look at the actual scientific acumen behind that, they are big business. There are good businessmen who are actually coming up with, I would say, uh, uh, who are coming up with they are not scientifically proven products many a times, but they are good branding. So you as a scientist, you as a pharmacist or a drug delivery expert, or maybe a pharmacologist or someone from pharmacognosy can utilize your expertise in to the nutraceuticals and the cosmetics domain. Secondly, I would say don't think of iontophoresis, the nanoliposome, aquasome, neosome. Let me tell you, the real ground reality is that people need oral tablets, oral pills, oral capsules. The oral dosage form still rules the world, basically. You just think of this that you as an individual or your family members, your kids, what would you prefer, an injectable or an oral tablet, basically? Look at the patient compliance perspective, right? Now, the market needs oral products. Coming up with any kind of invention there in is something which is, I would say, value addition and easy for commercialized. Think of medical devices, collaborate with biomedical engineering. They have lesser understanding of the scientific acumen, and collaborate with the dental colleges, and that is going to help you with respect to commercializing it. I would say with respect to the products. For the chemists, for the chemistry people, I would say don't go for new drug discovery. I'm saying this bluntly. I'm not here to demotivate you. I'm telling you based on my expertise of 20 years working with the companies, working with the law firms, working with major corporates as well as startups. And see, if you are in drug discovery, new drug discovery, you get really very nice results for preclinical for any of the disease. However, the kind of funding that is required, I would say, the funding is that is required, that is tremendous. No one is gonna bet on your science, basically. That is something which you need to understand. Work on salts, processes for preparing API. Now, entire world is going for the uh, green or environmental friendly. Try to utilize these. I would say, try to utilize these facts in your research, which can give you wonderful. I would say it may see the research is not about creating new drug. It is about improving the systems, improving the daily routine problems that you actually are having as such, right? And as I end this, it's the TTOs and not the incubation for pharma, basically. So that's it. I have my phone number, email address right here. I'm open for any kind of I would say questions here, which would be applicable for this specific session, or generally with respect to IP, with respect to commercialization, or any other specific activities as well. Those of you who asked for course detail, because uh, organizers, if Dr. Samresh allows me, can I share it for a second? The
Yes,
course
sir,
Hi,
detail.
sir.
hi Vijay. Am I audible, Vijay?
So this is my profile, and this is the LinkedIn profile. You can connect with me, and you just scan this code automatically. You would go to the 3 month certificate course, which is in patenting in herbal, Ayush, and nutraceutical products. Those of you who are interested can directly get connected with me as well. Yes, I'm open for the questions. Yeah.
Dr. Rahil Bura, sir, want to talk to you, sir. Dr. Rahil Bura.
Yes, sir. Yeah.
Hi, Vijay. How are you?
I'm all good, doctor. How are you doing?
Hope you recognize me.
Yes, absolutely. Yes.
Okay, so it was a nice session and it was a great to listening to you after a long break. And thank you for guiding my participant in a right way, in a right direction. Thanks a lot, and thank you for accepting my invitation on a single call. A
Yes, it's
special thanks for that.
all my pleasure, doctor.
All right, Mr. Samresh will close down this session. If anyone have any questions, so they can openly write down in a question answer session.
Yes, thank you, Rahil, sir.
Samresh, over to you.
Yeah, thank you, sir. The session is very insightful. I must say that everyone is getting lots of knowledge from your session, sir. I can see there are lots of messages in the chat box showing that the session is really great. So I'll take some questions from the audience. Please, you can use the React. button to raise your hand. So I will give you a chance to unmute and you can ask questions directly to sir. So Dr. Chitra, please unmute. Dr. Chitra.
Yes, sir. Uh, Good morning, all of you. And let me first congratulate Vijay sir for such an informative and really eye-opening session. So, sir, I have three questions to ask. First one, does the patenting agent help us till the level of grant? Usually they are doing till publication of the patents. So how they can help us defend during the grant interview or so?
So, ma'am, we have been doing it actually. So that's that. See, that's what is important. What is happening out many a times now? There are unfortunately certain practices, uh, wherein the person doesn't understand your invention. So, for example, an electronics engineer drafting your application, I said, "कुछ भी draft करो, file करो, publish होगा." That's why they are helping till publication. Unless the agent understands your invention, you should not
Yeah.
actually give your invention to that specific agent basically as such. There are a lot of pharmacists, rather MPharm or even PhDs who are patent agents. You can get those lists from the patent office website as well. But then I think, yes, we are doing it. As I said, I have run you through the entire process. We have got more than 88 patents granted already for the academic institutions as well. So I think, yes, the agents are in a position, and rather that's their job as well. You also need to check whether whomever you are working with. So there is patent office maintains a patent agent register. उसमें जाके check करो the person with whom you are dealing is a patent agent or not, and what's his qualification. Does he or she understand your invention? If the answer is yes, then only hand over your invention to that particular agent.
Okay, sir. Thank you so much. Then one more question, sir. Is there any additional cost of patentability report?
Okay, let me tell you how we work. As such, we don't charge for patentability because we understand the requirements that are there for, I would say, that are there for the academic institutions as such, right?
Right.
So, creating that patentability report is something which we waive off, for the academic institutions or universities with which we already have a tie-up, or we have signed more than 25 MOUs with various institutions, including the confidentiality disclosure agreement. We have been working with some of the best of the institutes in pharma as well as universities as well. So, yes, there are charges many a times for the patentability report generation as well. But then again, it should not be really very high in terms of, see, I'll tell you, what is happening out is when I compare a corporate client's requirement with an academic institution, then probably there is a big problem basically.
Yes, sir.
Yeah. So when for a typical lawyer or an attorney, if I am treating an educational institution, so I know the intent by which you are actually filing it, let's say. So in that case, I mean, it all depends basically. There is no hard and fast answer that yes, we
Okay.
charge for patentability many a times. But then with most of the academic institutions, we don't charge. The real cost starts only when we draft and file the application. Yeah.
Thank you so much. I am an academician and facing these challenges. That's why I asked these questions to you. Thank you, sir. Quite an informative session.
Thank you so much, ma'am. I have shared my WhatsApp
Yeah, I
as well
noted
as
that.
the
Yeah, I
email
noted that.
address in the
Yeah.
I would say,
I think I'll trouble you in future, sir.
for sure, I'll be happy to help you, ma'am. Yeah.
Yeah, thank you so much.
Thank you, ma'am, for asking question. Now I like to ask Dr. Rakesh Panda. You can please unmute. Dr. Rakesh Panda.
Yeah, am I audible?
Yes, sir. You can
Yes,
turn
sir,
on your
you're
video
on.
also. You can turn on your video also.
Okay. Hello, sir.
Yes, sir.
Hi, sir. Thank you for this session because actually my question is related to some rare diseases patentability. I mean, rare diseases, suppose CDKL5 deficiency and all. So, is there any separate or the timeline gap or something related when it comes for rare disease patentability from the beginning?
Rakesh ji, unfortunately, the answer is no, because patent office treats every invention equally. So,
Okay.
if you ask me, typically from a FDA perspective, approval perspective, you may get some advantage. But from the
Mhm.
patenting perspective, no, there is nothing basically per se. And
Okay.
while, as far as the processes or the timelines or the cost is concerned, there is no difference basically, Rakesh ji. But then if you look at the grant perspective, probably there may be an edge. Reason being, there is a concept called as inventive step, wherein for rare diseases, even since the research is very less happening on those rare diseases, so there may be an edge actually to get those patents granted, basically. But again, it all depends on how we portray it at the patent officer. Yeah.
So that actually the portraying towards the office, the application or the justification after publications, queries and all. So, do we always need a agent's help or we can also justify?
Rakesh, you can do that. See, what happens is, I'll tell you, as I said, typically at the patent office, we don't have pharmacists. You try to understand this very fact that you have a biotechnologist, someone from chemistry, or I would say, the biochemistry, they are evaluating your invention. Now, therein, it's not about the content, and I believe, I mean, that's what has been my area of expertise, or I've been doing it with so many inventions, basically, that now I know that trick to convince it's all about negotiating, sir. Right. And since these patent officials are government officials, basically, and so convincing them at times becomes difficult for a who is not from a patent domain. Okay, I'll tell you practical problems. You understand the technology, but you do not understand the difference between novelty and inventive step. Most of the inventions get refused based on inventive step, basically. Many times what we have also observed is that even the controllers recommend, they don't recommend any individuals, but they tell that, okay, why don't you take a help of a patent agent, actually? Because invention is good, but then probably you are not in a position to convince. वो controller को भी समझ में आ रहा है. And that's where I think the real challenge is, and that's where you should seek a help of a patent agent for, getting it granted as such. But it's not mandatory, Rakesh. Yeah.
Okay. Thank you, sir,
Thank you, sir.
for
Yeah.
your insight.
Thank you, sir. Now I like to unmute Dr. Shailendra Patil, sir. Dr. Shailendra Patil, please, sir, you can unmute and you can ask your questions.
Thank you very much, sir, Dr. Shivpuje. You have given very elaborative and very informative this lecture about the patent. I have two questions. Am I audible, sir?
Yes, sir. You're pretty audible. Yeah.
Yeah. I have two questions, sir. Actually, that my one of my students has filed a patent of of her dissertation work. Okay, and she has filed the patent without inclusion of my name. When I came across to know that she has filed the patent, I raised a complaint in the patent office. A long back, I think it was more than 3 to 4 years, but nothing has been done till date. So what should I do now?
Okay. Sir, these are common problems, and I think
Yeah.
I also had faced this issues from an agent's perspective, actually, like, now, sir, firstly, I would say as a institute or as an individual, the best thing is to avoid this. Now, to advise you at this stage, I would recommend to check what's the status of the application firstly.
Sure.
If it is published and lapsed, then there is no use basically for that. Even patent office is not gonna act. उनके पास बहुत सारे काम हैं instead of, like, working on a lapsed or abandoned case basically, right? That is one thing. Also, there are legal ways out to tackle this, to get your name incorporated.
Yeah.
See, it is not about you just raising the issue at the patent office,
Yeah.
but then it is about there is a procedure or the forms that are required to do that as such, and that need to be done through an appropriate channel as well. Again, sir, क्या है ना, एक गलती सुधारने के लिए there would be more cost, so it is always recommended to avoid it basically. But then, sir, I have shared my phone number as well. If you are genuinely interested and if you feel there is a value out of it, देखिए सर, ऐसा है कि like, if there is a value for the research, where there is a commercial value, there is a funding, in that case it makes sense to put money on that actually. Otherwise, at the end of the day, I believe it's your hard-earned money. You should not waste it. I'm using the word very carefully. I'm also a lawyer. I'm using this word, waste the hard-earned money, because I think at the end of the day, अगर उससे कुछ नहीं होने वाला, we shouldn't waste the money.
ऑफ कोर्स सर, ये बात तो सही बोला आपने, उससे कुछ नहीं होगा, लेकिन सर होता है ना कि एक लेसन तो स्टूडेंट को मिलना चाहिए। अगर वो इस तरीके की प्रैक्टिसेस में इन्वॉल्व
No, sir. Let me put it in a different way. Let me put it in a different way. It's not the lesson for the student. It's a lesson for you as a, I would say, researcher first. Secondly, क्या है, sir? Okay, I go to a forest and I kill an animal. Now, I have this excuse that, oh, I didn't know that killing an animal is an offense. I'll be punished for sure for killing an animal, right? Lack of awareness of yours is not an excuse, basically, right? As a researcher, as a faculty, and I think I must thank Sardar Patel College of Pharmacy for actually having this kind of topic at this forum. At least I would say, out of all these 300 plus participants, if we have at least some kind of awareness through this specific session, I think then that's the outcome of the entire FDP basically.
Sure.
It's not a lesson for the student. It's also a lesson for us. I would say in the long run, we have to avoid these kind of practices.
Yes.
And
Sir,
for sure, you need to have IP policy in place for sure, sir. Yes.
Yes, sir. I have another question.
Yes,
That we have been granted one patent, and in that application, that the name of all the applicants were not included. We have requested to the patent office for inclusion of another person's name in that one, but still that application is still pending. So what next we can do?
Sir, honestly, these are regular problems I face, and that's where I say it's better to take the steps upfront, basically. Sir, I struggled with a case for 3 years. Now, after 3 years, the applicant's name was included, actually. So, upfront karna is the best way out. Like, to answer your specific question, if it is to be added as an applicant or an inventor, I think the best way we say is that as an applicant, agar karna hai, so you assign the invention from 4 people to 5 people on a stamp paper, 100 or 500 rupees के stamp paper पे, notarize it and then show it like ये 5 लोगों ने ये 6 लोगों को rights दिए. Then it becomes easy to at the patent office, rather than adding an applicant, adding an inventor. The very first question comes is, why didn't you include it upfront? Was there a Malay incident?
Sir, the case is different. We have given the name of all 3 inventors as applicant, but the agent which have already dealt this application, he is not included in that. And when the patent was granted.
Okay.
Then it
Sir,
comes to know that sir, this was the mistake that
do you have the communication?
yeah.
So, sir, honestly speaking, there is a way, because see, at the end, as a patent agent, I don't have a right to include or exclude anything. If you have a proper communication, then you can approach the patent office for sure. And I'll take this offhand with you, actually, like, how this happened. And in fact, I'll tell you, there has been a recent case in 2024. One of the patent agent's registration he was debarred from being a patent agent now. So, and he is a M-Farm actually, based in Delhi. So, because of these malpractices, see, we as agents are not someone who has all the authorities. We are just representing you at the patent office because we qualified the patent agent exam.
Yes, yes.
My mistake never should impact you as an inventor. The patent office never mandates the applicant to take a help of a patent agent. अगर patent agent गलती कर रहा है, तो then you should not be suffering for that, and rather अगर इसका कुछ costing भी आता है, तो that has to be borne by the agent. Of course, patent office decides that accordingly. Sir, maybe we can get connected over a call to discuss this.
Yeah, definitely. I have some more questions which we'll discuss
Sure,
telephonically.
happy to
And
help. Yeah.
thank you very much, sir. You are you are from the pharma fraternity and you are heading and dealing with number of cases, and you are assisting, you are helping to this pharma fraternity. It's quite appreciable. I would like to congratulate you on this aspect. Definitely, and we will have definitely. I will trouble you in the next time. I will trouble you next time for some other matters. Thank you very
Sure.
much for your
Thank you so much. Pleasure.
nice presentation. Thank you very much.
Thank you.
Yeah, thank you, sir. Now, Dr. Sanjana, please you can unmute. Dr. Sanjana.
Hello, sir. Is it audible?
Yes.
Yes,
You can
ma'am.
turn on your video also if you want.
Sir, I have a question that for developing any devices, whether it may be for any test analysis or for any diseases, is it necessary that we need to develop a device, or it is only we are giving the 2D diagrams or something? Is it possible to apply such patents, sir?
Okay, yeah, that's pretty much possible. Rather, most of the devices for which we are filing, they are through the sketches actually, or the drawings for those devices. You don't need to basically kind of prepare, or you don't need to have those images basically for the device. I mean, that's what your question, if I'm correct, right, Dr. Sanjana? Hello. So, I mean, depending on how you are actually, I would say, what kind of device you have, you can for sure have that device in a 2D sketch form, and then you can move ahead with the patenting. Patent office never asks for the sample actually, but then it has to be workable. The model has to be workable actually, scientifically workable. That's what the message is, Dr. Sanjay. Yeah.
Thank you, Dr. Sanjana. Now, Dr. Sahil. Dr. Sahil, you can please unmute.
Yes, sir. Good afternoon. Actually, my question was like you said, like it is very difficult. Like you said, it is very difficult for a person to file NCs. But I have seen that BIRAC has a scheme which is there for translation. They give around some 50 lakhs, while if your product has been successful in preclinical stage, so that translation ka they have that fund. So using that, there are some chances.
So you are absolutely correct, I would say. But sir, 50 lakhs mein kya hoga? Can you do the phase 1 as well, post preclinical as such? See, at the end of the day, it all depends on, I would say, what is that funding requirement from. See, every agency is giving you funding, but sab mila ke bhi you cannot take the product to the market, unfortunately.
But sir, see, the government agencies are giving money and they are expecting outcome-based research.
Yes.
Now, if at all I am not able to, if at all I develop it, like it is not completely developed, so how the outcomes will be met?
I mean, see, firstly, I think I'm not the right person to comment on this actually, but then my perspective, this is my personal perspective, not representing any organization. With this disclaimer, I can tell you, see, at the end, and I think that's what my last slide included actually, what can be commercialized. I don't want, like, NCs, I have seen it with almost with the most of the biggest of the corporates as well, wherein they have the challenges with respect to, I would say, commercializing the invention. So where can you actually have a practical way to commercialize the inventions, maybe with respect to Nutra, cosmetics, some medical devices or processes, basically. That's the real, I would say, crux for the commercialization. Now, taking what, okay, I have a case study, I would say. I have a, I won't name the person basically here, but then she has a startup, and based on that startup, she got some initial funding. She took a product to phase one. For phase one as well, she got private equity funding, let's say, not the, of course, she had the grant initially by one of the MNCs to develop the prototype. So that was 50 lakh grant she got, 50 lakh ho gaya. The prototype was ready and all. She needed private equity. She sold private equity, got, I would say, some kind of results coming after the study. But then what after that? Your product is stuck there. You cannot have next level of funding at that point of time, basically, because as we know, for phase 2, phase 3, the real challenges would be, and okay, just as an entrepreneur, I'll ask, or even government thinks this way as well. What are the chances of success? Basically, there is always a chance of clinical trials getting failed. It happened with Revamilast actually, when Glenmark did phase 2b studies after putting so much of money. That point of time, the molecule failed, right? So putting those kind of investments into a high risk, high value product is something beyond, I would say, any one agency's bandwidth. That's what I believe. I would be happy to discuss this ahead. Yeah.
Okay, sir. Thank you.
Yeah.
Thank you, Sahil. Last two more questions I will take. Dr. Kalavati, please, you can unmute. Dr. Kalavati.
Very good afternoon, sir. It was an excellent talk. Actually, you gave the whole perspective in a very nice way. We had read about IPR, patents, all these things, but you had simplified it in such a way that the participants could understand it well. My question is, you had talked about the nutraceuticals and cosmeceuticals which can be worked on for these patents and the commercialization. So if you could just elaborate a little bit on that, because do we have to do a innovative thing over there, or from the scratch, which would be okay, sir?
Okay, so my perspective for nutraceuticals is that the barrier for entry to the market is very low. The costing that is required is very low for FSSAI approval compared to a typical pharmaceutical product. Selling nutraceutical product is comparatively easy actually. There is a market. FSSAI license also is not that costly actually. That's what I meant in terms of and again, when you think of nutraceutical products, and since the barrier is less, there is more of competition basically, right? And that's where I think it makes sense to come up with innovative products rather than just another me too product in terms of nutraceutical. Again, when I say innovative product, don't come up with something unorthodox and try to create a problem that need to be solved. Try to understand where is the lacuna, where is the gap, where is the vacuum in terms of existing therapies or existing products. and try to resolve that problem with the innovation basically. And I think that's where the commercialization can actually happen even for the nutraceutical products. Yeah.
Okay, sir. Thank you very much, sir. It was a very insightful talk.
Yeah, sure. Thank you.
So the time is now already 12. So, sir, you can take few more questions from the chat box if you want. Otherwise, we will go to close.
I'm happy to answer any questions.
Yes, yes, yes. So there are some questions also I can see from the chat box. You can please
Yes,
check
sir.
and
Yeah, let me take this one by one. Can we have different patent for same technology at different TRL levels? One at TRL, two at, I think that's a pretty interesting question. Yes, for one product, you can have multiple patents. So for example, I can give you a case. You at early stage, you can have it for a, let us say in a drug discovery, you can have it for a drug. Then you can have it for process for preparing that drug. Then you can have it for polymorph. Then you can have it for a composition. You can also, in few cases, have it for a typical dosage form. So yes, Dr. Mirza, you are right. You can have multiple patents for the same product at different stages. Rather, this is what all the corporates do. We call this as product life cycle management through the patent system, basically. Okay. Now, is it possible to get a patent on project? This is possible. We are working with one of the institutes in Gujarat, which is a central government institute, Ministry of Ayush ka hai, for which we are filing the patents for the similar, I would say, funded projects as such. Can we patent on the method validation and development? Is it possible? Now, this is a bit tricky. Method validation and development, if okay, how I portray this is like what you need to do is if you can show me the product or the product ka preparation process, then you can get a patent. Method validation mein kuch patents granted hai, but then how you draft it or how you put it is more important. Is there any agency for commercialization of granted patent? As I said, the TTOs I included in my slides, as well as NRDC, National Research Development Corporation, get connected with them. That would be something which would be useful. I think Dr. Mirza, how to apply for financial aid for international patent? Honestly, Umaji, there is no specific agency giving financial aid for international patent. If you are, so there are certain, like Kapila has a scheme of 5,600 rupees per application. Those 5,600 is 1,600 for filing and 4,000 for request for examination. If you are a MSME and have a Udyam registration, then probably you would have an opportunity to get it from the, I would say the MSME ministry, basically, which is again a reimbursement, actually, like, then there is a question by Dr. Monica Bodige. Sir, how we proceed our work after Indian patent publication? I would say, as far as the work, the lab work is concerned, then I would say there is nothing you can do. You cannot add any specific data in the specification. But I think I have already shared in my slides how it can be actually, like, taken ahead. Last question, I'll take this, Dr. Rakhi Mishra. Agents who can help for commercialization. I think I have covered this. Is in India, process patent is more relevant or new discovery patent is more acceptable? Both are acceptable, actually, like, and if any project is presented in an innovation competition, will it still be patentable? Yeah, thoda tricky hai, but then yes, the answer is yes, it can be, provided the like, if you are, let us say, you are doing it in Avishkar and all, and it is not recorded, or it is not specifically disclosed on website or any database, then probably you can still go ahead with that. Thoda sa risk hai, but then still it is possible. Thank you so much. It was very nice, and it was, I think, one of the most interactive sessions I ever had.
Yes.
It was very nice to interact with the faculties because I always believe that uh, rather than teaching, rather than teaching 100 students, if I can impact to one faculty, because they would be the one who can actually percolate the message or the values or the knowledge or the ethics that we have and the advantages of being a pharmacist actually to so many generations. It's all my pleasure to be here, and I take this opportunity to thank Sardar Patel College of Pharmacy for this specific opportunity. Thank you,
Thank you,
sir.
sir. Thank you, sir. It's very awesome. We are very glad to have you, sir. And very soon we are going to invite you in our campus physically so that we can really want to listen you in live. So I there are lots of messages I can see in the chat box and saying that it's very informative session. So, sir, just 1 second. Yeah. So, sir, please accept this certificate of appreciation from Sardar Patel College of Pharmacy and Gujarat Technological University as a token of our gratitude and recognition of your invaluable contribution. So, please accept this certificate. Yeah. So, thank you. So now I like to, sir, please be there for another 1 minute. I like to request all the participants kindly turn in your camera so you can take some screenshot. I request all the participants kindly turn on your camera. Just 1 second. So I think there is holiday, sir, right? In Gujarat, this is a government holiday due to Mahavir Jayanti. So still there were many people are there in the home and they are listening to you. It's really a awesome session and the participants are really want to know more about in this patent, how to exactly they can file a patent in future. Definitely, I think they can also contact you in future. So I believe all the participants has received the phone number of Vijay sir. You can please communicate if you need any help. I think he is ready to help. Right, sir?
Thank you so much, sir. I'll be, as I said, as a pharmacist and as a, I would say from coming from the same community of pharmacy, I would be happy to help any one of you. Also, I would like to mention here and just for the records, I have been traveling very extensively. Rather, I have traveled almost 30 states in India. Maybe I have visited your places as well, and I would be whenever I'm there next time, I would be happy to meet all of you or some of you at least in person as such. And there are a lot of government aided IP awareness programs that also we conduct, and I will be happy to help you with that as well, to get connected and conduct those offline programs at your locations. Thank you.
Thank you, sir. Thanks a lot. Thank you again to for accepting our invitation and for delivering this such a insightful session. Thank you, sir. Now I request all the participants kindly please give your available feedback, which is there in the chat box. I request all the participants please kindly fill the feedback form is already shared in the chat box. Thank you. And one more thing, tomorrow we are having a very nice session on AI because nowadays people are having some fear whether they have to use AI or not. So, how to use AI ethically? For that, Dr. Sumeran is going to present a very insightful session. And there will be one more surprise announcement for all of you. Please be available tomorrow. Don't miss the opportunity because as a pharmacist, we should also know that how AI can also use for our day-to-day academic as well as in research. I believe that tomorrow's session will going to give us a lot of information. So please don't miss tomorrow's session. And after the session, there will be one announcement I'll going to announce after the session tomorrow. So please be available on time by 10 o'clock to listen Dr. Sumayarani. She's going to speak on about AI ethically for research. So thank you all to be present over here. So see you tomorrow. Thank you.